Hi everyone, how are we all doing? Thank you all for joining us early, and it's good to see your beautiful faces. So I can see Chelsea, I can see Folakumi, I can see Favor. Thank you all for joining us. Folakumi will be moderating today, so please you can take over and start the meeting. Thank you all for joining early. Thank you all for joining early. I can see Oyeyinka, Oluyinka, sorry, Ibuchim, Uzowa. Thank you all for, and they're just ladies. We are the guys. And you all are looking beautiful, by the way.
Thank you, Mama.
You're looking beautiful. Thank you.
Thank you, Ma. You're welcome, everyone.
Moderating can.
Okay, Ma. Thank you very much, Ma. All right, welcome, everyone. You're welcome to the third week of the third quarter of Jiipcc's mentorship program. So my name is Folakumi. I'm a 4th level law student of Olabisi Onabanjo University, and I'll be your moderator for today. All right. So quickly, the registration for the 4th quarter of Jiipcc's mentorship session is ongoing. Kindly tell your friends, your classmates, and everyone you know will be interested about the program. And you're also encouraged to put on your videos we are streaming live, and I'm very sure when you come back to check the videos on YouTube or Facebook, you will really like to see your beautiful faces. And also edit the name session on your account and fill in your full name as you are taking attendance. So if you don't have your full name on your Zoom account, I want you to kindly go there and fill in your full name or change the name to your full name. Okay, also registration for Jiipcc's end of the year party is ongoing, and the party will hold Saturday, December 10 at Abuja. And I'm very sure the registration link, yeah, that's the picture. And I'm very sure the registration link would have been sent to your group chat. So if you would like to attend, kindly fill the link. Okay, so before we go into the presentation and the program, I'd like to read out the mentor's profile. Okay. Sorry, I'm waiting for this thing. All right. So we have Mrs. Amosa Shukrat Modupeola. So Amosa Shukrat Modupeola is a proficient consultant, analyst, and educator in the field of intellectual property with public sector experience. She is a member of the World Intellectual Property Organization Committee and has a master's degree in intellectual property at African University, Zimbabwe, in conjunction with WIPO and the Japan government. She has partaken in professional training at the World Intellectual Property Organization, as well as other IP-related bodies, and has facilitated numerous intellectual property-related programs, both online and offline. Shukrat is the pioneer of an educational platform, DIN, the Intangible Knowledge, which facilitates IP awareness and bring the knowledge of intellectual property closer to everyone. In celebration of the 2022 World IP Day, she partnered with other stakeholders to sponsor 5 IP enthusiasts and registered them for WIPO advanced courses. Amosa is an accredited agent at the Nigerian Intellectual Property Offices, Nigeria Copyright Commission, Trademark, Patents, Design Registry, and her expertise are, but not limited to, trademark, patents, industrial design, copyright, and trade secrets, respectively. Thank you very much, ma'am. We also have Iloduba Ogochukwu Clementina. So Iloduba Ogochukwu Clementina is a senior assistant registrar, one at the Trademarks, Patent and Design Office, Abuja, Nigeria. Thank you very much, ma'am. And we are, yes, ma'am. And we have Ayuketa Oswald Tambe. Ayuketa Oswald Tambe is an intellectual property freelance consultant and researcher, holder of a master's degree in intellectual property from Africa University, Mutare, Zimbabwe. At graduation and in addition to his master's degree, he was awarded a certificate of excellence for best graduating student who has demonstrated leadership potential in intellectual property with $500 cash prize donated by the African Regional Intellectual Property Organization, ARIPO. He also studied an online course organized by the World Intellectual Property Organization Academy on intellectual property management. At graduation, he was awarded a certificate in advanced course on intellectual property management within the framework of a program made possible under the new collaboration among WIPO, the Korean Intellectual Property Office, KIPO, the Korean Advanced Institute of Science and Technology, and the Korean Invention Promotion Associate for WIPO alumni candidates. He has been enlisted as a potential beneficiary for the second time of a scholarship for a blended course on IP assets management from a practical business perspective. He's also a graduate of the Rwanda Institute of Legal Practice and Development and hold a diploma in legal practice and development. I will be writing the bar exam this year. As a freelance researcher and consultant in intellectual property rights issues, he liaises and interacts with international, regional, national educational research and technology institutions, as well as young entrepreneurs group in his capacity as general manager of a civil society NGO known as Cameroon Intellectual Property Awards Association to provide counseling and updates on intellectual property issues and trends, especially on the innovations of the newly revised Bangul Agreement. Thank you very much, sir. So thank you very much, everyone. I hope our presenters are ready. So you only have 8 minutes to present. Please be time conscious and please manage your time very well. All right, so presenter for group 1, you can share your screen now and present. Group 1, are you ready?
Yes, I am. Please give me a moment to share my screen. Good evening, everybody.
Good evening.
Share screen. Good evening, everybody again. Please let me know if you can see my screen.
Can you see
my screen, please? Pardon me?
Yes, you can.
Okay. Good evening again. I'm Damilola Busari, and I'll be representing Group 1. Before I go into the basics of, or the full thrust of what we're talking about today, a couple of years ago, I watched a movie that I'm sure a number of us have watched. It's an Indian movie called 3 Idiots. And if you pay close attention to that movie, beyond the humor and the fun, you would realize the importance of what we're about to share to you today, which is intellectual property protection for engineers. In that movie, you had engineering students. One of them thought outside of the box a good number of times, and he came up with interesting inventions in the movie. And at the end of the movie, you will see that he became a great engineer with thousands of patents to his name. Today, I'll be talking to you about how innovators in the engineering industry use intellectual property. So engineering is a dynamic sector with valuable research, innovation, and breakthrough technology. The engineering profession often embraces scientific discoveries of new materials as well as processes. Engineering and mechanical engineering, and I would also extend this to what we have with artificial intelligence as well, produce the components and products that facilitate our modern lifestyle. Every single thing that we enjoy today is a product of engineering. Our phones, our laptops, our computers, in fact, the internet as well, that we are using to have this class. So intellectual property helps competitive advantage of any engineering company. It helps the company grow its market share as well as its reputation. We all know that intellectual property protection, there are different ways with which you can protect your intellectual property rights. Different ways include patents, copyrights, trademarks, trade secrets, as well as industrial designs. Now, for engineers, because of the kind of work that they do, they are constantly coming up with new innovations and inventions to help our world. It's important that they protect their intellectual property because that's where all the juice is and that's where all the money is. So competition, as expected, competition is good because without honest competition, there will be no new innovations. People will tend to rest on their oars. Though it is good, they must pay attention to protecting their intellectual property. The different ways that they can do this include patents, especially utility patents, copyright, as well as trade secrets. And the bulk of my presentation will be showing you those ways and different companies that have, or different case studies where these inventions have been protected and some where they were not protected. So let's start off with patent. The patent, I'm sure we all know what that is, but just to remind us, it's the main intellectual property protection that is available for inventors. And WIPO has said that it's the right granted by a government for an invention, which is a product or a process that provides in general a new way of doing something or offers a new technical solution to a problem. There are different types of patents. You have utility patents, design, provisional patents, as well as plant patents. Now, utility patents grant to anyone who invents or discover any new or useful processes, machine, article of manufacture, the composition of matters, as well as new improvements. Because we know that engineers deal with machines, a lot of new inventions fall under patent. And so this is very, very important to them. It's safe to say that intellectual property protection available for inventors in the engineering industry is patent, as it prevents or excludes all others from making, using, or selling their invention without their authorization. In Nigeria, the legislative framework governing the use of patents is the Patents and Designs Act 1970. Now, the case study that we have here is the drone, which is very popular these days. You have this now used for all sorts of things, ranging from media coverage to a wide range of uses. But here's how this came about. Vanderlip Edward G., an engineer for a particular aircraft corporation, invented the helicopter drone, and he gave it the patent name Omnidirectional Vertical Lift Helicopter Drone. It was patented in 1962, and it's relatively recent, it's less than 100 years. Despite the fact that a lot of people have now improved on this invention, the picture you can see here is obviously an ancient drone. If you see new drone models, they are not like this. But because he did the hard work of patenting the he's still credited as the person who is the owner of that invention. Let's take a quick look at copyright, which is another way that engineers can protect their intellectual property. Now, the main thing to note here, computer field now, would be their software and their programmings. Computer programs rather, it's what makes inventions possible in that world. So copyright protects programs. In Nigeria, for instance, Section 39 of the Nigerian Copyright Act includes a computer program as part of the literary works that can be registered and protected under copyright. Now, a sad example is karaoke. A lot of us have gone to events and we've had a great time playing karaoke. Diasuke Inoue was the person who came up with the concept of a karaoke machine, but he didn't get any money from it because he didn't think it was a big deal and he didn't go ahead to patent it. So right now, karaoke machines are found all over Tokyo and in fact, all over the world, but he doesn't have the due credit that is due to him and he didn't make any money off his invention. Next, we have trade secrets. Now, a trade secret, according to the Black's Law Dictionary, is a formula, a process, a device, or other business information that is kept confidential to maintain an advantage over competitors. It is why Coca-Cola is still Coca-Cola today. A trade secret is very, very important for anybody that works in the engineering sector. Now, there are different ways that you can protect your trade secret. You can do that either through the confidential or non-disclosure agreement. Alternatively, excuse me, please, you can use a non-compete clause to protect your trade secrets as engineers. Now, an interesting case here, which is a good one, is Cumulus versus Leventis Motors Limited. In this case, there was a former staff of Leventis, that is Cumulus, and he had gone ahead once he discovered the trade secrets of his employer to resign employment and go work with a competitor. However, he had a clause in his employment agreement that said that for a period of 1 year, he can't carry on or undertake any other partnership or business in line with the business of merchant engineers. So the court awarded a fine against him because he had gone ahead to collaborate with his former employer's competitors. He appealed the case, but the employers won the case because they had that clause in their agreements with him. Conclusively, like I said at the very beginning, competition is fierce in the engineering world, and it is that competition that helps that industry to thrive. However, because of that as well, it's very important that you don't fall on the negative side and begin to count your losses. And what you do to ensure that you don't fall on the negative side is that you protect your intellectual property in whichever way that you can, either using patents, copyrights, or trade secrets, as these are the most appropriate intellectual property protection methods available to those in the engineering industry. Forgive me, I'm rushing because I have 8 minutes, but I believe I stuck to time. Thank you very much for listening.
Well, thank you very much for that presentation. That was very informative and educative. Thank you very much. So you can stop sharing your screen, and group 2 can start sharing your screen now and present. Group 2, are you ready?
Hello, Miriam is supposed to be the one to present, but in case if she's not around, I'm the backup presenter.
I'm here. Can you hear me?
Yes, we can hear you. You can start presenting.
Okay. Okay, good afternoon, everyone.
Sorry, can you see my screen? Good
Yes.
afternoon.
Good afternoon.
Okay.
Yes.
I am Akiola Okwemirian, presenting on behalf of Group 2. Our topic is on how inventors in the communication industry use intellectual property. So first, I'll give a brief overview of the communication industry and how IP rights come to play in the industry. So basically, the communication industry is also known as the telecom industry, and it refers to entities or companies that are in the business of conveying information. The term was primarily used to describe telephone operating operators, but due to the technological industrial revolution and due to the technological industrial revolution, the industry now includes internet service providers, cable television services, cellular, wireless telephone, and so on. The communication industry makes communication possible on a global scale, whether it's through airwaves, cables, the phone, or the internet. As of now, the global telecom services market size was valued at $1,657 billion in 2020, and is expected to expand to a compound annual growth rate of 5.4% from 2021 to 2028. So as you can see, the communication industry is one of the most dynamic and innovative sectors of modern economies. The communication industry is full of innovators who continue to produce and improve the services they provide. Therefore, this calls for the need for IP rights to protect such innovations. So now the innovative firms in the industry, they protect their valuable products and services through patents, trademarks, copyright, and industrial designs. Just like other industries, innovators in the communication industry depend on IP protection as a source of profit and as a strong weapon for protection from their competitors in the country. IP protection establishes an environment that fosters creativity, enables growth, enables competition, innovation, and exploits the transformative potential of digital technology. We have, next slide. We have international brands like Huawei and ZTE that are now paying attention to building their intellectual property strategies in order to access foreign markets and come in direct competition with world-class enterprises. Now, to fully expatiate on the IP rights in the communication industry. Okay. IP rights protection typically focuses on patents in the communication industry. However, in practice, IP strategies are developed by combining different IP rights. First of all, we'll speak on patents. So companies in the communication industry, they give protection to their devices and products using patents. By patenting, companies exclude third parties from using or selling their products without permission. The inventor have a monopoly, and this monopoly is safeguarded, and the credibility of the company in the market increases through patent registration. However, it is important to note that companies in the telecom industry, they cannot operate in isolation. And this is where what is called interoperability comes in. So simply put, interoperability is capacity for a service or a piece of equipment to be operated by different groups. That's how we have telecom companies in Nigeria. We have like MTN and Airtel. They operate together with interoperability. So interoperability in the communication industry ensures the smooth flow of information and data between telecom devices made by different companies. It is also to ensure that different patent holders can maximize their different innovations. And how this works in the industry is through licenses. Okay. So these are different licenses issued under patents in the communication industry. This includes, we have unilateral licenses, patent pools, cross licenses, and standard essential patents. So basically, unilateral licensing, the patent owner, who is the licensor, allows the licensee to use an invention in exchange for compensation. Now, under patent pools, which is common in the wireless communication industry. In this case, at least two companies, they come together and agree to license their patent for free or at a predetermined royalty rate to one another or to a third party. This kind of licensing allows for overlapping or interconnected technologies in the industry. Now, to the third one, which is cross licenses, is when in which there's a strategic alliance whereby companies grant a license to each other for the exploitation of inventions of an approximately equal value. So lastly, we have standard essential patents, which cover the technology required to implement a technology standard. This allows for connection and data sharing between companies. So next, I'll move to the next intellectual property rights, which is copyright. As we all know, copyright protects the artistic ideas of individuals and is considered the lifeblood of the media. Copyright guarantees the protection of creative minds without affecting the creation of new media, and it protects the inventor's work from the usage of others. Sorry, please, are you still hearing me? Is everyone still with me?
Yes, we can hear you.
Can hear you.
Thank you. Copyright guarantees the protection of creative minds without affecting the creation of new media, and it protects the inventor's work from the usage of others without their permission. So companies can be copyright in the communication industry. Companies can be copyright owners through what is known as works made for hire. I'm sure you can see it here. Works made for hire. And these are works created by an employee within their scope of employment or certain independent contractors owned by and these works are owned by the employer since it's created under their employment contract. So next, I'll move to trade secrets. So basically, trade secret is any information that a company would not want its competitors to have. Some examples of trade secrets that require protection in the communication industry include new business models, customer and suppliers information, marketing strategies, processes, and formulas that they used to come up with different technologies, and other confidential business information. Companies in the communication industry need to utilize their trade secrets to protect their confidential information and as such. So next, I'll move to trademark. And trademark is how customers recognize a company in the first place. It's how we recognize different companies like MTN, like Airtel, like I mentioned before. So trademarks are largely indicators of commercial capability. And due to the concept of interoperability in the communications industry, companies can easily distinguish their products using trademarks. For example, trademarks play an important role in customers distinguishing international telecom brands like Airtel and MTN from each other. Their trademark has what has established notoriety and credibility for them in the industry. So next, I'll move to a case study of revenue gain and loss in the industry. So our case for this is, we have the case of Christopher Omari and another versus Safari Limited. So this is a Kenyan case, and in this case, the plaintiffs forwarded a written proposal of an idea. The idea was the emergency credit service to Safaricom Limited, a telecom company. The company then forwarded an indemnity form to the plaintiffs seeking their signature. However, the telecom company failed to respond to the proposal letter and then went ahead to launch the telephone program, which is Okoa Jahazi. And this program is one that provides emergency credit to customers, which is similar to what the plaintiff forwarded to the defendant company. So a suit arose as the plaintiff sued the telecom, accusing them of stealing their idea. Safaricom defended itself by alleging that he already knew the concept by learning about it from Vodafone operators, which are another telecom company, before receiving the proposal. The court dismissed this case, and it has already been successfully implemented in places like Lesotho. Also, the plaintiff failed to produce cogent information. The plaintiff failed to produce cogent information, cogent evidence to support the claim that they owned the idea. From the decision above, it is clear that Safaricom Limited, the telecom company, continues to gain revenue as a result of the mobile programming force, while the plaintiff lost a lifetime opportunity to gain revenue for failing to protect its copyright. Also, we also like to state the recent case of MTN, a telecom company in Nigeria, in which they had to pay 20 million naira in damages to a musician for using his song Love Over Everything as a ringtone to their caller tunes for years. And the musician argued that he never surrendered the master tape and the right of the song to the entertainment company, but they used it for years as caller tunes to millions of subscribers without his consent. So from the cases above, conclusively, it is clear that the communication industry is full of emerging innovation. And for inventors to thrive in this industry, they need to come up with effective intellectual property rights strategies that will ensure the maximization of benefits that we ordinarily accrue to holders of intellectual property holders, rights holders. Thank you.
Right. Thank you very much, Yugo. So thank you very much for that presentation. You can stop sharing your screen now. And group 3, I hope you are ready. Group 3, you can present now.
Hello, good evening. I'll be presenting for group 3. My name is Mariam Man. I'll be presenting for group 3. I'm trying to share my screen.
Oh, okay.
Saying you can't start screen share. Oh,
Sorry, I already unshared it, I guess. Sorry about that.
Oh, all right. So group 3, you can share your screen now and present.
Okay, good evening. Can you see my screen? Good evening.
Yes, we can. Yes, we
Okay.
can.
So I'll be presenting on behalf of group 3, and our presentation is on intellectual property for inventors. Primarily investors in the medical and pharmaceutical industry. So basically, an invention is the creative ability of a person's mind. It's very often described as the bedrock of innovation, maybe an improvement upon a machine or a product or a new process for creating an object or result. So basically allows inventors to invent new things or to advance on inventions, like already made inventions. So for the medical and pharmaceutical industry, they need IP protection and sorry, excuse me, sorry. Intellectual property is the bedrock on which advancement of new medication and cures take place. Without it, researchers might not be able to explore new areas of medical innovations and uncover discoveries that will prompt future treatments or cures. So types of IP protections that are available in these industries are patent, trademark, copyright, and trade secrets. For patents in this field can also be referred to as medical patents. Medical patents are exclusive. They are government-granted rights that protect an inventor of a unique medical product, process, or technology against unfair market competition. It prevents other individuals or entities from producing, selling, or using the patented item, idea, or method for a duration of 20 years from the date of application. Medical patents protect a wide range of inventions. This include and is not limited to pharmaceutical drugs, medical devices, medical procedures, and medical software. While trademarks, on the other hand, trademarks and logos are especially important for those into pharmaceuticals. And a pharmaceutical trademark and logo help and protect the brand of the company and its product. Ensures that consumers don't get confused because without a strong trademark, it's possible for consumers to tell the difference available and counterfeit products. This time, trademark just like on good mark of like products, just like everybody knows like products to help companies and protect good name, like good their product. Then also of medication errors, healthcare setting, and also incentivize.
Miriam, sorry, we cannot really hear you.
Sorry, I don't know if my network or where I am.
Okay, you should your phone or your system. We can hear you now.
Okay, I'm very sorry. Please, where did I cut off? Okay. Where exactly? Maybe I should take it from trademarks again.
All
Trademarks
right.
and logos are especially important for those into pharmaceutical industries, those that produce drugs. Then a pharmaceutical trademark and logo helps distinguish and protect the brand name of a company and its product. It ensures that consumers do not get confused because without a strong trademark, it would be impossible for consumers to tell the difference between available and counterfeit products. Then it also reduces the risk of medical error in the healthcare settings and also allows manufacturers to be deliberate about the safety and quality of their existing products. Copyright, on the other hand, helps them to protect original medical publications, software, blog posts, or website content. Without filing for copyright protection, one lacks any legal leverage against any person who plagiarizes their work. Copyright lasts for the lifetime of the author plus 70 years. Trade secret. A trade secret is information that a company chooses not to share and is only valuable as long as it remains a secret. When a company maintains intellectual property as a trade secret, it is important to have non-disclosure agreements with the contractors, manufacturers, distributors, and anyone who came in contact with the secret. Trade secrets, however, do not have long-lasting advantages. It is impossible that some may discover your secret through reverse engineering or some other incidental process. Then a well thought out analysis is required before deciding to just keep your IP as a trade secret. Eligibility for protection. Although IP laws exist to protect a person's intellectual creations, there are certain requirements those intellectual creations must fulfill before they are eligible for the protection. For any copyright work to be eligible for copyright protection, is considered patentable if it's new, results in an inventive step. It must not be obvious to a person that is experienced must be capable of industrial application. Then we have case studies of how inventors in this industry have benefited from IP protection. We have Joel Gibbard. He's the founder of Open Bionics. His company produced patented assistive devices designed to aid people with special disabilities. Then we have this Joel Gibbard is an inventor in the medical field. Then we have Emzor. I think we all know Emzor, paracetamol, and I think they have this cough syrup too in Nigeria. So the Nigerian-based pharmaceutical company and is well known for producing the popular analgesic paracetamol. Then importance of IP in the healthcare industry. It protects medical invention. It it drives economic growth and competitiveness, it provides protection for consumers and families, and it generates solutions to global issues. It provides protection against potential infringers. Then, conclusively, then the healthcare industry is growing, and for basically for the public, like the world, to I don't know. I don't know if it's my network. I think they can. The sorry, please, can you hear me?
Yes, you
Yes.
can.
Oh, okay. I'm sorry. Then conclusively, then the IP protection basically just allows we humans, like in general, to be able to benefit from science, because if everybody's claiming, okay, this is my invention, you can't work on it further. Basically, we just be at a standstill. I'm very sorry for this poor presentation. Thank you very much. That's all.
All right. Thank you. Thank you very much for the presentation. Thank you. All right. So group 4, you can share your slide now and present.
Sorry, please, can the person start presenting while they're trying to share?
Hello, can you hear me? I think your mic is muted, Richard.
Yes, you can.
You can start presenting. You only have 8 minutes.
Please, can we have the backup presenter start the presentation if the main presenter is not available?
Yeah, I can do that. Can anybody hear me?
All right, yes, we can hear you.
Okay, so do I have to
Can you hear me now?
Okay.
Hello?
All right, we can hear you, Richard.
can hear you.
Sorry. I had to switch to another device. Okay. Good evening, everyone. My name is Adeyemi Richard. I'm presenting for Group 4. And our topic is intellectual property for inventors in the tech space. So the first slide. So IP is often the most valuable asset of a technology startup. Protecting intellectual property is essential to obtaining venture capital funding or preventing competitors from unfairly competing with you. Inventions are protected under intellectual property law through patents, designs, and it protects profits and tangible assets of an inventor. So intellectual property in the technological invention. So in order to understand the role of tools in an IP system, it is first necessary that we look at the technological innovation as an interactive process which consists of a number of varying stages. So IP in technology begins with formulating a unique idea or concept and going through several stages when a new and improved product, and it ends when a new and improved product is launched and marketed successfully in the marketplace. Tech innovations consider practical IP issues that are relevant at different stages in the entire process of product development, beginning with the producer and ending with the third user. The tech innovation and IP starts with the idea stage and moves to the research and development stage. Technological ideas can be protected with IP rights, but it is the duty of the inventors to be up and doing in getting the ideas protected. Because of time, intellectual property. The intellectual property includes the patents, the copyrights, trademarks, and technical know-how. The creators or owners of intellectual property are legally entitled to protect their property from unauthorized use. So because of time, I'll just skip to the importance of intellectual property for inventors. So the importances are IP rights encourages innovation and rewards entrepreneurs. IP rights enhances inventor business market value. And IP rights can also help a creator to stand out from its competitors. By this, intellectual property serves as the foundation of innovation for every economy. Artists and inventors are encouraged to transform their ideas into reality, invent and develop solutions, and create new products and technologies, which will in turn help to improve the country's economy and promote investments. Now, how to protect your IP in invention in the tech space. First of all, you file a provisional patent application. That's filing so that you are granted a patent to your invention so that no one else can use it. And you put it out there to the public that you have an invention so that they will know it belongs to you. And you do that by using the right patent, the trademark, and the copyright markings for the idea. And also keep accurate communication records. There can be because there can be certain moments when introducing your idea to a potential partner or buyer. If you give too much away, the new party could make a mint and shut you out of the process. So it is important to be able to prove what happened then. Something like this, if you all know about Facebook and how it came to be, something like this happened there, where Mark Zuckerberg came, he spoke with the Winklevoss twins, and they gave him the idea, but he came up with the code, and they all had some lawsuits or some issues with that right after. So now, type of intellectual property rights. We have the patent, the copyrights, the trademarks, service marks, trade secrets, confidentiality agreements for employees and consultants, terms and service and privacy policy. So in copyright is aimed at protecting creative works of the human intellect in text space. So it relates to literary and artistic works, but it is not limited to literature and music. And it also includes such technical expressions of the human creativity, such as the software design, electronic databases, multimedia productions, applications, and all other forms of technological development. A copyright is what you need to protect the way your software solves a certain problem. It doesn't protect the idea behind your product, but rather the way this idea is implemented. Copyright in technology applies best to source code, the object code, and user interfaces. Its protection gives the owner the exclusive right to authorize or prohibits the reproduction, distribution, translation, adaptation, broadcasting, or communication of the idea. Now, patents. A patent protects inventions. An invention can either be a new solution to an existing problem or an improvement to an existing invention. And for an invention to be patented, it must possess an inventive step and be capable of industrial application. That is, it must be capable of practical use. It must be able to be used practically. And it protects the idea behind the particular product, but not its execution in form of code. Patents often protect software architectures and proprietary algorithms, and it gives the inventor to sue those who infringe. For example, our main case study here is Ericsson and Xiaomi. So in 2014, Ericsson filed a suit against Xiaomi for the alleged infringement of their 8 standard SCPs. Now, SCPs are patents that protect technology essential to a standard. Now, these SCPs are indispensable when manufacturing products such as smartphones or tablets. And these patents are considered very essential when producing those products in that industry. And it cannot be exploited like any other patent, and it cannot be eliminated to other market participants. So the plaintiff contended that the licenses were offered to be granted to some companies on fair, reasonable, and non-discriminatory terms. But however, these companies refused to undertake such licenses, and they were now using the patents without the license and were infringing on the plaintiff's SCPs. So the Delhi High Court granted an ex parte injunction on the sale, manufacturing, and advertisement and import of the defendant's devices. But however, the defendant claimed that the latest devices in the Indian market contained the chipset which implemented technologies appropriately licensed by the plaintiff. So the defendant subsequently challenged this injunction before a division bench of the Delhi High Court, and the defendant was temporarily permitted to resume the sale and the manufacturing of the mobile devices, subject to certain conditions, which would only sell devices having the licensed chips and will not amount to infringement as per Section 107 of the Patents Act. So the court held that the plaintiff had purposely withheld the facts about his license and has failed to show a prima facie case. And in the span of 2 years, Ericsson has sued various companies like Micromax, Intex, and Xiaomi for the same issue. Micromax and Intex had approached the CCI. However, the investigative order passed by the CCI suffered a major blow because the Delhi High Court held that it conflicted with its jurisdiction. So the case highlights how patent holders use the law sometimes to extract large sums of royalties and license fees for use of their technologies. Now, trade secrets. Trade secrets have to do with the proprietary information that a technology company discovers and works with. And they are usually not registered with any authority, but they are maintained indefinitely by members of the company or partners until they are discovered by another company in the market. And the best way to protect your trade secrets is to execute an NDA, that's the non-disclosure agreement, or a confidentiality agreement, to dispel unnecessary worry about entrusting information on your idea or project to another. And the last one I'm talking about is trademarks. A trademark is a distinctive, recognizable word or word, slogans, domain names, shape, sound, or a combination of any of these that represents or identifies a company or its products or services, so as to distinguish it from other particular groups, goods, or services in the marketplace. So for instance, trademark protects distinct names of goods, such as Samsung, Infinix, and Apple, and it also protects services such as OPay and Paga. Now, another example is Sonos. Sonos is an American company that produces audio devices. And so Sonos won an order from the United States International Trade Commission, which found that Google infringed on 5 Sonos patents and it's barred the importation of validating products, including Google's Nest audio speakers and Pixel phones. So this is Google's first loss in the ITC, and the ITC found that Google infringed all 5 asserted patents and rejected all of Google's invalidity arguments. And as a result, every asserted claim survived and every Google product accused in the complaint was found to infringe. The ITC's importation ban covers not only Nest speakers, displays, streaming and connectivity products, but also the Pixel phones that control them. So in conclusion, as technology continues to alter and change the very fabric of how we live and work, it is clear that almost every industry is set to be or already being disrupted by innovation. So the importance of IP rights in tech should be obvious, and ideas are often seen in the currency of the 21st century, and yet it's the ability to protect them and their value. And this is the core focus of IP rights. The ideas should be protected always, and the idea owner must make sure his or ideas are fully protected for his benefits. Thank you.
All right, thank you very much. Thank you very much for this presentation. You can stop sharing your screen now. Okay, so quickly before our mentors give their comments, I want you all to turn on your video. Let's take our pictures before we give them the chance to make their comments. So turn on your video and take a screenshot. You can post it on LinkedIn, write the things you've learned, and make sure you tag your mentors and tag Jiipcc also. Okay, so I hope you are done taking pictures. All right. All right, thank you, everyone. Thank you, everyone. So I'd like to call the mentors now to give their comments on the presentation. So Mrs. Hamosa Shukrat. Hello, Mrs. Hamosa Shukrat. Okay. All right, I don't think she's here presently. So let me call Mrs. Ogochuku Clementina.
Okay.
Okay, ma.
Hello. Thank you very much. Good day, everyone. Hello.
Right.
I hope you can hear me.
Yes, we
Good
can hear you.
evening, ma'am. It's
Yes,
not
we
very,
can.
not very
Oh,
clearly.
it's not clear enough. Oh,
Yes.
can you hear me now?
Yes, we
Oh,
can.
okay.
I can hear you clearly.
Okay, it's already getting clearer.
Oh, it's better now.
Yes, it's better now.
Okay. Good day, everyone. My name is Clementina Iloduba. I'm Senior Assistant Registrar, Trademark, Patent and Design Office, Abuja. First, before I make my comments, I would like to commend the speakers. They did so well. Thank you very much for your brilliant presentation. But in a nutshell, I will not be talking to the speakers group by group. I'm going to speak in general to the presentation. For the presentation, I think that the speakers, they did well, but in making the presentation, I observed that they didn't include in most of their presentation the laws governing trademark in Nigeria. They didn't talk about the office in charge of registering intellectual property in Nigeria. Then I think it's group 3 or is that group 3 or 4 that talks about types of intellectual property rights. They didn't mention design as part of intellectual property rights. That's industrial design as part of intellectual property in Nigeria. So in a nutshell, I'm going to give an overview of registration of intellectual property in Nigeria. Because intellectual property, you don't get to know who is the owner of intellectual property if it's not registered, except for copyright that doesn't really require registration before you can determine the owner. But in determining owner of intellectual property, other types of intellectual property like trademark, patent, industrial design, is registration that gives you the ownership. So let's take, for example, in terms of chaos, or if there is conflict in respect of an intellectual property, you can only say you are the owner if it's registered. But in a situation whereby it's not registered, it's very difficult, even to the court, to determine who the owner of the intellectual property is. So let's take trademark. Yes, like the presenters have said, trademark is what distinguishes your goods from that of other people. So if you have a brand name and you wish that such brand name to be known for your product, you have to register it. The office in Nigeria that is in charge of registering such intellectual property is Trademark, Patent and Design Registry, which is located in Abuja. So if you have a brand name and you wish to register such brand name, the first thing you do is to do what we call availability search. Hello, you can hear me?
Yes.
Hello.
Yes,
Yes, I can hear you.
Okay, so the first procedure is to do what we call availability search. You conduct a search to know whether the name is free or not. When you are done with search, the next procedure is to go on with the registration of such products. So in registering, you have Form 1, Form 2, Form 3. That's Form 1 is Form 1 is authorization of agents. Then Form 2 is what we call it, a form that contains the details of the registration. It contains the name of the trademark. Let's say, for example, if we sought to register, let's say I want to register my name, Clementina, and maybe I'm doing cosmetics and I wish to register it in class 3, which is the class for registration of cosmetics. So after I've done the search, I have to get Form 1, which is authorization of agents, Form 2, which is the details of the name, the company, the address, email, phone number. Then I have what we call Form 3. The Form 3 is the specimen of the name. So this is my name, Clementina. The specimen of that Clementina. So attach it with a logo or a device. That's Form 3. Then you proceed with registration. So when it gets to the office, there's a people in the office we call examiners. They have to look into the name which you sought to be registered, because it's not every name that is sweet to the ear that is registrable. No. A name might be sweet to the ear, swish, but at the same time, it's not registrable. So if the name, examiner now look at the name, examiner will check, is this name distinctive enough? Is the name against public policy? Does the name contain names of national flag or states in Nigeria or Nigerian currency? If the name is devoid of all these that I've mentioned, the examiner will go ahead to approve the name. And when the name is approved, the name will be published in what we call Trademarks Journal. After it has been published, publication is for the world to know that, oh, so and so name is to be registered by so and so people. So after the name has been published, then if there is no opposition in the sense, if nobody is saying, okay, the name ought not to be registered, or the name looks like my own, or all that. If nothing is said about the name, we go ahead and issue certificate of registration. The same procedure goes to patents, the same goes to industrial design. But patents, if a patent is granted to a person, it doesn't mean that it's not automatical that you have to go and use the name. No, the law requires you to do some things, like there are some other agencies that you need to, consult before you can go ahead and use that invention. Let's say NOTAB. If a patent grant is granted, you have to go to NOTAB to make some registration. You have to go to raw material. If the invention involves something that has to do with raw material, you have to go to raw material and also obtain license before you can go ahead and use the invention. So that is that. Then for industrial design, before you can register an industrial design, it has to be new. For example, a design that's already in the market cannot be registered and it cannot be acceptable. Let's assume that I have a clothes and I designed the clothes and I have already opened it in the market. I cannot come back to register it in the office because the name is already known in the public. So it cannot be registered. So I think in a nutshell, that's just the process for the registration of trademark, patent, and design. So if you have any question as to this type of these types of intellectual property registration in Nigeria, feel free to ask. Then, okay, let me say, there's something I forgot to say, sorry. I forgot to say that in Nigeria, because I noticed that most of you keep saying utility patents. In Nigeria, we don't offer utility patents because our law does not permit us. What we offer is patents, so most softwares goes to copyrights. That's where you register them. Although there's something in place, we're trying to see if we can be registering utility module patents and business method patents. So that's all. Thank you.
Thank you very much, ma'am. Thank you so much. We'll come back to ask all the questions after all the mentors have given their comments. Thank you very much.
You're welcome.
So, Mr. Amusa, I don't know if you are here now, ma. Okay, so We'll call Mr. Ayoketa.
Can you?
Oh, Mrs. Amosa, good evening. All right. Thank you, ma'am. Can give your comments now, ma'am.
Everyone, it's good to be here again. So I'm just gonna give some comments on the presentation. Group 1 presentation was very nice, as in it was educative, short, visible, and it was clear. But I think other groups, the font was too small, so you actually cannot read it except you are reading it for us to understand what you're saying. So next time you can kind of make the font bigger enough for us to see. So the topic is on IP and invention. So majorly, just like we said, copyright is the linchpin of the music industry. So patent is the linchpin of the invention industry, like the technical software computer. Okay, so when you talk about patents, like what does patent do? You know, patent doesn't protect the functional aspects. It protects more of the technical aspects. So your work has to have an industrial applicability, it has to be new, and it has to be novel. Sorry, it has to have it should not be obvious, rather. That's inventive step. So when you say your work should be new, it doesn't mean your patent should be disruptive, like you can do an upgrade on what has been on ground before. It doesn't have to be entirely new. You can just put 1 or 2 things together to make it new. As long as you can claim that what I have in my patent is not existing in a prior act, then you are good to go. But as long as what you are doing is existing in a prior act, then you can't do that patent. So one important thing about patents is disclosure. If you are not ready to disclose your invention, then don't talk about patents. Because for you to it's just like a trade by barter. You are giving the government your invention and government is giving you protection. So once your protection has elapsed, what's the benefit for the government? The government is going to push your work out there so that other people can actually use your work and do 1 or 2 things to kind of benefit the society. So it's just like a symbiosis process. You are doing this for me, you protect my work, and I give you, in exchange, I'm giving you my work as well. So without disclosure, you can't patent. So that is why they say, don't disclose your work before patent, because once you
Hello, everyone. Can you hear me?
Yes, we can hear you.
We can hear you.
I think
Yes, we can hear you. I can hear you.
All right. So I think she has issue.
And confidentiality agreement. Okay. So service mark and can you hear me?
Yes, we can hear you now.
Okay. So service mark and confidentiality agreements are not classified as types of IP. Like they are just subs under some IP rights. For example, when you say trademark, under trademark, we have the service mark, we have the collective mark, and we have the what do you call it now? Certification mark. That's under trademark. But when you talk about trade secrets, then you can now say, okay, you can use a confidentiality agreement to actually protect your trade secrets or non-compete. So non-confidentiality is not a type of okay. My network is fluctuating.
Maybe you try to put your video off and see if it will be better.
Okay, okay. But can you hear me now? What was the last thing I said that you heard?
certification mark and collective mark.
Okay, so I was saying under the trademark, we have service mark, we have certification mark, and we have collective mark. But you can't classify them individually as types of IP. Do you get? So you just say trademark. Then under trademark, all of those marks are under trademark, but they are not individual on their own. Then just like the previous speaker said, you didn't mention anything about industrial design. Neither do we have geographical indication. So all of those are also types of IP. So for patents in the health space, you know, most times this health patent is kind of dicey because you have some people that really need that invention, and the patentee will say, no, I can't drop my invention unless you pay so amount. So to actually make all these things easier, there are kind of flexibilities on patent, just like we have compulsory licensing. So if your government can tell that person to license their patent compulsorily, it's going to benefit the masses as well. So another one is the fact that because it's a medical patent, most times once the patent is granted, they don't use it immediately. They have to like undergo some other processes to check if the health measures are put in place. So most times their patents start running before they start using the patent. So the best thing is government give them like maybe 5 years plus to make it 25 years. Sometimes it depends, might be 7 years, depending on how many times I've lapsed for them to actually put in place all those health safety issues. So most times you see some health patent lasting for 25 years instead of 20. The extra 5 years is to like accommodate the lapsed years whereby they're not using the patent to actually put in place all the safety measures as well. So when it comes to patents, the other speaker spoke about trademark. So to register patents in Nigeria, you have to do a search. Like search is very compulsory because don't go and start planning an invention that is already in existence. So you go and do your search and you see that the patent is already in existence. So the best thing is to do your search, number one. So once you've done your search, then you have to look at your specification. In your specification, you have your title. Your patent should have a title. You have the inventor's name. Then you have your abstract. You have your abstract, like a summary of whatever it is you are doing, a summary of the claim, kind of. So you have your abstract, your background, your drawings, and your claim. So when it comes to claim, like claim is the heart of patent. If another patent is existing and they have the same claim, then that patent will be considered infringing. But if just one element of that claim is different, then it will be considered infringing. So whatever it is you are doing, make sure you are capturing it in your claim. Your claim is protected enough. So I'll give you an example. So let's assume I want to protect a cup that has an handle, but my claim only majors on the cup, and somebody else comes to claim the handle. That person is not infringing on my patent because I didn't claim handle while drafting my patent application. I hope it's clear enough. So whatever it is you are trying to claim, whatever it is you are trying to protect should be in your claim. If it is not in your claim, then it's not protected. That's actually like everything it is that you try, just put everything. But don't and that thing is, don't limit your patent. Don't claim red cup or blue cup or white cup. It doesn't have to be color. Somebody else can create a black cup and say your claim said red cup, mine says black cup. Just say cup. Do you understand? So cup encompasses every other cups that can be there. So I hope that's understandable for patent. And what else do we have on patent? Okay, another thing is because of the health line, most times it's really hard for health to come about their patent once. Sometimes they do more of research. So these things you can apply for a provisional patent, although most of these things are not applicable in Nigeria. But I think the utility model is applicable to some extent. Like if you go to the patent registry and you have a patent and your patent doesn't meet up with the requirement, they'll kind of advise you to like come down to maybe utility model. So you just don't go home and feel sad. So you can actually do a utility model. So we have utility model, we have provisional patent, and that majorly applies for the health sector. Provisional patent saying, okay, I have this patent, I want to register. Well, I'm not done with carrying out the research and all of that. So provisional patents will give you, like, you can register it first, then you have, after 12 years, you can now register the main patent. Do you get? So professional is just like keying a space down for yourself, like, okay, before that 12 years elapsed, you now have the main patent which you want to register, which is the non-provisional patent. Because once that 12 years passes and you didn't register it, then it will automatically turn to your non-provisional application. So you can have a provisional patent as well for the health sector, majorly advised for the health sector and probably the technical aspect as well. So I guess that's all I have to say. Thank you.
All right, ma'am. Thank you very much, ma'am. Thank you so much. Okay, so we have Mr. Ogochukwu. Sorry, Mr. Ayuketa Oswald. Hello, sir. You can give your comments now.
Sorry, is Mr. Tambe with us? Mr. Tambe. We cannot hear you, sir. Maybe you'd try to talk directly to your device.
Hello, everyone. Greetings. Are you getting me?
Yes, sir, we can hear you.
Me?
Yes, we can.
Hello? Hello? Are you
Yes,
getting me? That's exactly what I'm doing. Okay. Good afternoon, everyone. And I am Tambe Uzol Ayuketa from Cameroon, the General Manager of Cameroon Intellectual Property Awards Association. I wish to commend all the presentations so far, and I think they have done a wonderful job. And I want to commend Amoza and the other speaker before Amoza for their mentorship message. I would not wish to repeat all what they have said because intellectual property has the same rules in almost all the same countries, similar principles, definitions, but they're different. So I wish to add one or two statements to the presentations and the statements by the mentors. For the presentations, it would be interesting if, in addition to case studies, they try to use hypothetical cases to illustrate what they mean by patents, trademarks, infringement of trademarks, and the other intellectual property rights which exist. How are they infringed? And that would enable us to understand more, and they themselves will understand what it means, because a lot of it is what we read from the textbooks and from the internet. We would need them to start acquainting themselves what happens in reality in their various countries. With regards to our mentors, what I could add, I wish to add as well is that their explanations are very enriching, and I equally learned something from what the mentors who have spoken already have presented. But I wish to equally emphasize the importance of intellectual property in Africa today, because both the two major intellectual property associations are RIPO for English-speaking African countries, most English-speaking African countries, and OAPI for the French-speaking African countries, in addition to major giants in Cameroon, in Africa, like in Nigeria, Egypt, and other African countries. The principles are the same, but the trend now is to harmonize all of these principles so that we see how we can look in one direction and try to make sure we have a platform that enables us Africans to fight and protect the democratic rights of our people and inventors. You see, we have engineering and civil as well, but their work is not being protected as intellectual property. Lack of awareness and knowledge about how to protect their domain. I followed also the intellectual property involved in the healthcare were being highlighted. And that's a very important aspect because all of us, we need more drugs for our health, but these drugs cannot come without research, and a lot of money is being put in the production of these drugs, and many devices which are medical equally involve a lot of inventions. So there is need for us to identify the intellectual property in such domains like in the health domain, in the mechanical, in the engineering domain, even in the plant, in the agricultural domain. We have plant patents which come in to support researchers and inventors who come up with new plant species, for instance. May I add equally that the aspect which I was interested in the presentations was that of who owns the intellectual property in a particular dispensation. The ownership of a patent, for instance, is the person who comes out with a new idea, the new inventive idea, and which is novel, which has a industrial application, and which is not existing anywhere after research has been done. Very important. We have to take this into consideration and know that 2 or 3 of you can come out with an invention that is you are the owners. But if there is an agreement, for instance, to employ somewhere, and the employment agreement says whatever thing you are inventing, that will have to now own your rights. So the important thing is to be careful that you read the IP clause and make sure that you agree or you make a. But if you are on your own, you are a consultant, independent consultant or contractor, the right is your own. The IP right in anything you research and invent is your own. But depending on how you agree, you can agree to assign such a right to the employer. That would be understood. But be very careful. And that's why you need attorneys and lawyers to guide you that when you are entering into such engagement, you should be careful to know which clause should be modified and which one should not be modified. There are equally aspects like when you leave this employment and you have another employment, what do you do with the IP that you got from this other side? Do you use it with your new employer, or you make sure you don't violate, you don't infringe in the proprietary rights of your former employer? Those are all considerations which normally come up when we are discussing employment opportunities. May I equally add that the aspect of utility models, we are in Africa and the rest of the developing world, we need to highlight the importance of utility models, because utility models are little patents. They call them brothers of patents, because they are not it's not difficult to get them registered. And the conditions, the prerequisites to get them registered are not as high as for patents, because for patents, you must carry out the research as one speaker spoke. Then secondly, there must be that inventive step that is showing that there's something that is really, really out of the obvious that you are doing. Whereas for utility models, you need just novelty and it's capable of industrial applicability that is capable of solving a technical problem. I don't know whether there will be other questions for me to think. Madam Moderator, it would be an interesting event if we start organizing additional webinars where you get people with experience in the field as well to share their opinion with those who are students who are still being groomed to join the platform of intellectual property for us. And may I end that the initiative by our Africa Continental Free Trade Agreement of putting in place PIPO, that is a structure that has a harmonized protocol for intellectual property, is laudable, and that most countries in Africa should make an effort to be part of this initiative, because it is an initiative that makes Africa tomorrow to be able to have and sell the gold that comes with intellectual property more than the agricultural product, because intellectual property is a goal of this 21st century and and the centuries to come. Thank you so much.
Okay, thank you very much, sir. Thank you, sir. So yes, we have questions already in the chat section, but then I will read them out and call our mentors to answer. Okay, so the first question we have here is, okay, so since paracetamol is now considered generic and cannot be trademarked, how can companies that produce paracetamol like Emzo make good money and distinguish themselves in the market? So can you, sir, please answer the question, Mr. Oswald?
Yeah, when I read the question, I was asking how his preoccupation is with regards to paracetamol and how how it should be trademarked. You have a product, you want to distinguish it from others. You need to get a name, a design, your product, and the aspect. That is how you can trademark it. But if paracetamol is already in the market as a trademark, you cannot use it again as a trademark. You understood the question being asked by the participant. You got me?
Sorry, the line was breaking, but I think he has answered the question. So maybe we can also throw this question to another mentor to answer.
Did you get my answer?
Not really, sir. The line was breaking.
Did you get my answer, please?
The line was breaking, sir, so we did not really hear you.
All right. What I'm saying is that if I got his question well, he's asking that paracetamol cannot be trademarked. So what can he do to get the product either in the market or something like that? I think, and I was saying that if paracetamol is already trademarked in the market, he cannot use the same paracetamol as a name to distinguish line, a different name, identify it with the product and its quality, so that consumers will know it and know that it is its own and not the other paracetamol. If I got the question well.
Okay, all right. Thank you, sir. Okay, sir. Okay, so the next question is, how should ownership of a commissioned invention be determined? So, Mrs. Clementina, can you please answer this question for us? How should ownership of a commissioned invention be determined?
Okay, thank you. The ownership of a commissioned invention is determined through one, registration. But if it has to do with patents, in patents, there is what we call true owner and statutory owner. True owner is actually the person that did invention, whereas statutory owner is the person who actually registered the invention. Because you can be a true owner, but you didn't register invention. But the law allows you to, for the name of a true owner to be mentioned in the process of registering the invention if the true owner is not actually the person that is registering it. So a commissioned invention is like an invention that has been assigned to someone. So if an invention has been commissioned, that is, has been assigned to the person, so the person whose the invention is assigned to is the true owner.
Hello.
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 Hello. Okay, ma. Thank you, ma. Okay, ma. The next question is: how is ownership of inventions by employees determined?
Well, this has to do under the master and servant relationship in law. You know, there is these principles that says that whatever an employee has belongs to the employer. The same goes to intellectual property. Let's say, for example, if an employee has an invention in the course of his employment, literally under the law, is deemed to belong to the employer. But like I said, under patent, if it's patent or industrial design, the name of that employee in the process of registration will be mentioned by the employer, who I can say is now the true, I can say is now the statutory inventor, that is the statutory owner. So if the employer is coming to do the registration, he's like the statutory owner, but the law allows him to mention the name of that employee who actually did the invention.
Okay. All right. Thank you very much, ma'am. Thank you, ma'am. Okay. So the next question, Mrs. Shukrat, please. How effective are utility patents in the engineering sector?
So utility model, utility patents in the engineering sector. So you have to be able to distinguish what utility model is from patent. So it has its own advantage and disadvantages. When it comes to utility model, you can say utility model are like small patents. They are not so, the process is not as tedious as that of main patent. And utility model, the protection time is limited. It's 7 years for protection instead of 20 years for patents. So the utility model, you don't need or doesn't really require inventive step. So your invention might be new, but it doesn't really require inventive step. And that's a major requirement when it comes to main patent invention. So if you don't have inventive step, then you can now fall under utility model. You can use utility model as a backup to like protect your invention. Then when you now have another invention that has utility model, you can go ahead to file for your main patent. So utility model are majorly like smaller patents. You can do that first while you're busy upgrading your main patent or busy working on the main patent. As well as that, you can also file for provisional application, which is 12 months frame before you can now file your main patent. So it depends on what exactly it is you are working on. We'll give you the decision to say, is it a utility model or a main patent you want to file?
Okay, all right, thank you, ma. So the next question is, how can the role of intellectual property in the health industry be influenced? Mrs. Amusa.
The role of IP in the health industry, I think we are already saying it. It's just that most times these people, they do so many researches and they don't end up getting the money they invested in those researches because the government will ask them to compulsory license their inventions and all of that. So there are still kind of flexibilities. If, for example, when the COVID-19 hits and we have to like get a drug to actually cure COVID-19, you see they told some medical researchers, like whatever it is you are doing, you have to reduce the price for probably developing countries who can't buy that product at that particular price. So that's actually, it affected the inventors, but the government will kind of like give them something to like encourage them for whatever it is they are doing. So the IP in the health sector is still somehow clumsy because they feel like they are not getting the benefits they need. So we are still on it, Sha.
Okay. All right. Thank you very much, ma'am. Thank
You're welcome.
you for today's session. I don't know if Mrs. Juliana Imam would like to say something.
Okay. Thank you so much for Lakumi for today. Thank you for moderating this session. I think it was a very insightful session. Sorry, they just took the light here, so you can't really see my face. But I really want to say thank you, Polakumi. Thank you. Moderating with that bright smile is just amazing. And then to all the mentees that came together to research and work together, we're so proud of you. Thank you so much. And I can see beautiful faces. I can see Amosu, I can see Libretta, I can see Benjamin, Uzowa. Thank you so much for your time. Thank you for researching. Thank you for working. You are really doing well. And I want to encourage you to continue cooperating with your team members and encouraging your team members to finish the program, because some people can get tired or some can get discouraged. So it's important that you encourage them. If you've started, you can finish. And with that, I really want to say a very big thank you to our mentors, Mr. Tambe, Mrs. Clementina, and Amusa. Mrs. Amusa, thank you so much for coming. Thank you for sharing from your wealth of experience. We are so grateful. And I want to encourage the mentees, even if it's just to pay attention and listen, it's very important. By the time your clients come and they start sharing their experiences with you, you might not have the time to start checking a textbook or something, or when you're in a radio station, you're in a TV interview, you might not have that time to start checking all these things. But if you listen to some of these lectures, by the time you're doing a live session or you're on television or you're having your radio interview, when they ask you a question, you won't be dumbfounded. You will not be blank. You would have something to say. So please try to listen to this. Also try to go to the YouTube channel, listen to the sessions, listen to previous sessions so that it can help you understand the topics better. And then finally, I want to talk about the private mentorship session. It is very important. Some of the mentees complain that they don't have like a one-on-one relationship with the mentors. One of the ways that you can have a one-on-one relationship with the mentor, that the mentor can say, this is my phone number, call me, this is my office, come, this is my house address, come, is when you take advantage of the private mentorship session. Now, there are about 20-something people here, 30-something people. The mentors here cannot really know your names or your faces. But if you take advantage of the private mentorship session, then they get to know you personally. And then you can reach out to them on a more personal and private level. So with that, I want to say thank you to Mr. Hussein. Thank you for working on the back end of the program. Thank you so much. And to everyone, I see what you're doing and I see the hard work that you're putting into what you're doing. And I want to say thank you very much. To our mentors once more, thank you. Thank you, Damilola, for that presentation. I think it was a beautiful presentation. Well done. And to every other person that presented, you did very well. Know that I am proud of you and we are all proud of you. So with that, we'll be coming to the end of the session for today. You'll be getting your topics for Friday. Please, I would like you to just give an e-clap for the mentors. Just do like this. If your videos are on, just do like this. Let them see you. Good, good, good. Let them see you. Let them see you. Yay. Thank you so much. Thank you, Amosa. Thank you, Mrs. Clementina. Thank you, Mr. Tambe. We are so grateful. And feel free to post on LinkedIn and write what you learned and tag them. And for the questions, finally, please send in your questions when you're researching these topics. I'm sure that there are some questions that come up, send it. That is what will make the discussion rich, when you send your questions and they now get to answer it. So with that, I want to wish everyone an amazing weekend. Thank you all. Love you all. Bye.
Bye.
Thank you, Ma.
Thank you
Have a
very
lovely
much.
weekend too.